Hi, I'm Greg Dell, joined by attorney Stephen Dell, and we're going to discuss a common question that we get, which is, do I need a disability insurance lawyer when applying for benefits? And I know even though people probably did a Google search and they're thinking about this process, should I apply on my own? Do I have to have a lawyer? And I know a lot of people call you because we always offer a free consultation, which I highly recommend everyone takes advantage of that. But ultimately, I know you get the question is, do I need a lawyer and why? And what do you usually tell people in this situation?
So that question is a common question that I get from clients both on the internet, but more so in a phone conference. And they've already sent me their policy. I've looked at their policy, and it's the initial call to go over fitting the pegs in the hole. And after we've spent 30 minutes, 40 minutes talking about their occupation, talking about their impairment, what the doctors say, that their doctor is or is not supportive of the claim at this time, before they conclude, or I conclude, a typical question is, and by the way, do I really need a lawyer? And I think they're surprised by my response, because it's generally, no, you don't have to have a lawyer. You don't need a lawyer. However, it would probably be in your best interest to have a lawyer. And it's sometimes scary for the claimant because when they hear the word lawyer, they think of adversarial type engagement. And they think that a lawyer is going to be someone who's battling. We will fight for you. That's not what it's about. It's about utilizing our expertise to navigate the disability process such that everything is presented in a manner most favorable to the claimant, to the insurance company, so that the insurance company is placed in a position that if they legitimately review the claim, they have to approve the claim. And when I say legitimately review the claim, that's a presumption that sometimes is just not there. Because the carriers often look for a way to deny a claim. I don't believe, and there are some carriers, some very good carriers, that look at a claim in a manner, how can we approve this claim? And they're few and far between.
Yeah, those are rarities.
They're rare. Although, I've got to say, I spoke to a Mass Mutual claims administrator who called me and said, are you sure your client doesn't want to be on claim any longer? Because the client said, you know what, I'm feeling somewhat better. I don't want to take their money anymore. And this particular claims administrator said, I've read the medical records, I've looked at the diagnostics, I understand this case well. Steve, we've paid your claimant for 2 years. They continue to qualify. So there are carriers out there.
Well, there's some that are better than others, and also, regardless of the company, they're also a human being at the end of the day that's behind that file.
You would hope so.
And there's good people and bad people in life, and there's people who bring their personal life experiences to the table of this, and there's some that are really in it and have compassion and emotion for a claimant, and there's others who only care about the company and go, my job is to evaluate the claim, and if I see a reason to deny it, because that's how many of these claimants are trained, I'm going to deny the claim. Whereas some of the other companies tend to look more to just say the facts are the facts, and if they're disabled, great, and if they're not, they're not. But more often than not, it's looking out for, oh, they're missing this, not enough information, denied. And that's usually what 90% of the denial letters say. Insufficient information to support restrictions and limitations. So, that's unfortunately a known entity when dealing with these companies. But back to the do they need a lawyer and the role that ends up becoming yours as the lawyer. You say, no, you don't really need a lawyer, but what is the advantage of having you involved?
So there are instances where I tell the potential client that you should have a lawyer. And those are instances where, for example, I was discharged by my employer because I wasn't performing up to the standard that I was required to. And the reason why is because I was sick. I couldn't multitask. I couldn't follow through. My memory was impaired. I felt intimidated. I was afraid. I was urinating regularly in the bathroom because of the stress. And they discharged me. And I had been seeing a doctor. That claimant has the potential of being denied because he failed to discuss with his employer that he was undergoing a sickness. There were restrictions and limitations, that he couldn't perform his job. The door was open for the carrier to deny the claim. And what I have to do is review the terms of the policy, word by word, to determine a manner in which I can present the claim so that the carrier can't deny it on the basis that there's no coverage, even though that claimant hadn't informed their boss, their employer, that they were suffering from a medical infirmity. That's a case where they need a lawyer.
But I also want to bring up to your attention, like, I find 80% of the calls that I get for applications are people, but for the person who had an accident or a significant unexpected diagnosis that just came about, they've been suffering with chronic medical conditions for months, sometimes as long as 2 or 3 years. And more often it's several months, and they're battling through it, thinking they're going to get better. And they work through that condition. And then the disability company goes, but I don't understand. You've been working with this condition for years. What was the changing event all of a sudden that you couldn't work anymore?
And that's what I call what has changed. Because the carrier does look at the medical history, does look at the performance that the claimant has had at the job, and it's a legitimate question. Why now have you hit a wall that you can't perform your duties any longer? And in most instances, the person has just become more progressively ill, more progressively limited, and before you walk away from work, I advise the claimant, go to the doctor. Tell your treating physician that I have been trying to do the duties of my occupation. I've been trying to get by. I've been trying to do what I've been trained to do, but I just can't do it anymore. And tell your doctor why. I'm sleeping less. I'm more fatigued. I'm more anxious. The pain in my legs are so bad that I can't get up from my desk and walk to the water cooler. Ask the doctor to document those things. That's what I look for, so that when I do present the claim, everything is laid out for the insurance company. The insurance company basically has a checklist, and they want to know, here's the definition of disability. Does the person meet the definition of disability? And they're looking at the occupational duties, what the medical records reflect, and they're fitting the pegs in the hole to determine, is this a claim that we're going to approve? Is this a claim we're going to summarily deny? Or is it a claim that we're going to send to a in-house or third-party medical reviewer? That's called a peer review. And the peer review is really going to scrutinize that claim. And the focus is not to approve the claim, but frankly, is there a basis to deny the claim? Carriers are in the business of collecting premium and making money, and they do make money. They are not in the business of paying claims that they don't have to. And it's our job to make sure that we present a claim that they have to pay.
But I also find that the carrier set the process up from the inception to either deny or what we say delay a claim. And the reason I have this belief and see it on a daily basis is because even the initial claim forms that they send to a claimant, that many people watching this video are sitting at home with, are limited in scope. Meaning they don't ask for everything that they really truly need to evaluate the claim. And I believe the disability companies do that intentionally because they want you to just submit your initial application, submit an attending physician statement, and then, as you know, often they ask for 5 or 6 more things. Now, that doesn't happen to your clients, which you can explain why, but you know they set those forms up like that with limited space to explain everything and attending physician statements with limited space to say anything. So how do you deal with that when you're representing a client to shift the dynamic back to the disability company such that when you submit an application, they can't call you up and say, Mr. Dell, we need more information?
Greg, in furtherance of what you've just said, many of the forms, which are the standard packages that go out to the claimant, will have an attending physician statement. The attending physician statement is the form that the doctor fills out that certifies that at this time the person cannot do the duties of their occupation. And often, one of the questions is, have you advised the patient not to work at this time? Yes or no? When did you advise the patient of that? When will the patient be able to return to work? And what's really almost funny, it says, unable to determine at this time is not an acceptable answer. Well, does the doctor have a crystal ball? Does the doctor know when and if you're going to get better? Of course not. So that stumps both the doctor and his or her patient, which is our client. There's no preclusion from writing on the form, next visit is June 4th. We will determine at that time. I want the carrier to have something that is appropriate and at the same time is reasonable if they've asked not to indicate unknown at this time. And doctors are comfortable because there is an upcoming appointment. They're going to reevaluate, and at that point, they can either continue or not continue the support of the claimant's inability to work. And there are multiple questions throughout where have you advised the claimant to not work? Yes. And then there's one line as to explain in detail. And there's one line. The carrier doesn't invite an additional form. Sometimes they do. Generally they don't. I will tell the client often that I'm going to just attach the medical record and we're going to put in see medical record because we will prepare you how to discuss your claim with your physician, and you're prepared to advise your doctor of what your symptoms are. Your doctor can't read your mind, so a good medical report attached to an application answers all the questions for the carrier before they even ask it.
In the claimant statement, which is the equally as important when submitting a claim, there's two important topics I want you to touch on. Number one is selecting a date of disability, which is absolutely critical. And number two is establishing the occupational duties, which I don't believe that claimant form provides enough opportunity, but yet is crucial in every single disability application because every application always starts with an own occupation definition of disability, which is unable to perform the substantial material duties of your occupation. But the claimant statements usually just say, what's your occupation? And don't really go much into the duties or things like of that nature. So how do you, number one, establish the duties beyond the scope of what they provide there? And also, why is it critical to choose the appropriate date of disability?
Okay, so before I address the date of disability, let's talk about giving the carrier enough information that they understand the claim, both from an occupational and a medical or psychological point of view. What I do, and I think our firm is known for this, is prepare something that I call the personal statement. The personal statement is the theme of this particular claim, advising the carrier of everything they need to know about what's going on. And I prepare that, which is generally with the assistance of the claimant. It's a multi-page document which, first of all, addresses the history of the claim. I haven't been feeling well for many months. I've been going to the doctor. I've been working, doing the best I can, but failing at what I've been doing.
It's your story.
It's
the story.
It's the theme. It's the story. It paints the picture that a two-page claimant's statement, which is the application, isn't going to inform the carrier of. Then I get into, occupational duties. And I actually give a checklist early on in my representation to the client, asking them these questions, and send me an email answering, what do you do? How do you do it? Why do you do it? And it's generally 2, 3, sometimes 4 pages. Often, they can just go to HR and they get this 4-page document that explains every single thing they do for their employer. And the bigger corporations actually have occupational descriptions. I attach that to the application for benefits, and then I ask the claimant to tell me, what are your symptoms? And they'll send me a bullet point often with 10, 12, 15 different specific descriptions of difficulty to walk, difficulty to sleep, daytime fatigue, unable to get in and out of my car. Every case, of course, is different. And then, on the personal statement, I disclose why these symptoms impair the claimant to perform the occupational duties which the claimant has assisted me in identifying. Also, in this personal statement, I include how I spend my day. What is it like when I'm outside of work? For the mom who also works, are you able to take care of the kids? Are you able to go to the supermarket? Are you able to do the standard duties around the house that you did? Have you asked your husband for help? Or has the husband asked the wife for help? Because often there are shared duties. And then I conclude it with something personal from the client, generally saying that I've done the best I can, I hit a wall, the reasons have been disclosed, and it finishes with, because of the stress associated with this and my need for assistance, please communicate with Stephen Dell, who will be more than happy to respond with my assistance for any questions that you may have. And it works great. And by the way, I just want to add, the carriers know us for that. They don't ask for it. Maybe they don't ask for it for a reason, but it gives them everything before they ask for it.
And not only that, so you put together an extensive claimant statement, you work with the client to guide the doctor for completion of the attending physician statement, and then when everything gets submitted, and even from the, depending upon when the claimant contacts you, but you are the voice for the claimant. Meaning,
yes.
Explain what that means.
Well, I'll get a call from the claims administrator. Hey, Steve, thank you for the claim. Thank you for giving us all the information. And through my assistant, they're going to want to set up often an interview. And what's good is the days of, at least with our law firm, the days of the claims investigator going to the claimant's former place of business or to the claimant's home are over. We generally shy away from that, and our agreement with almost all of the carriers, both on the group side and the individual side, is they'll do the statement wherein they want to question the client for additional answers that weren't provided or weren't obvious in the claims brochure we presented. They're going to want to interview the client. And it's generally done telephonically now. Since COVID, no one really wanted to get together with other people.
Or via Zoom.
And it's rare even for Zoom because I generally don't want it to be Zoom because it's very stressful for a client. They're not used to being on a camera, and it's just more comfortable just to talk on a phone. And we schedule it generally a week or 2 or 3 out. The carrier already knows everything they need to know because I've given them the personal statement. So the questions that they ask are more times than not going to be repetitive to what I've already informed them. And I talk to the client beforehand, and we have a prep session. I don't tell them what to say because, of course, they have to answer truthfully, honestly, and completely. But how to answer a question is something we go over. Not to be intimidated by a investigator, and I tell the client what questions you're likely going to be asked, because regardless of the claim, the questions are always the same. There are always issues specific to a particular claim, to a particular diagnosis, how that diagnosis affects you at work. There are questions often specific to your occupation that might have perhaps not been evident from looking at the occupational description. And I ask the client to think about those things. And generally, our clients do great, and it's not the stressful exercise that they anticipated it would be.
So you've talked about many things that you do for a client and the reasons why they need a lawyer. But in terms of once you're on the claim and you send in that letter of representation, can the companies contact the claimant directly?
Our letters of representation state, please do not contact the claimant. Please, all communication should be through our office, and that we will be expedient in responding to any and all requests. And I want to say that the relationship between us and almost every carrier is a give and take relationship that's fair, honest, and quick. We don't keep the carriers waiting, because that's going to delay a decision on the claim.
Well, you've definitely covered a lot of the issues as to why someone should have a lawyer. Now, I know that you always offer a free consultation for anyone who wants to have their policy reviewed, whether they're considering applying or they're already on claim. And for anyone out there, I encourage you to call Stephen, myself, any of our disability lawyers. And again, we offer this service nationwide, and we look forward to the opportunity to assisting you.